Legal dictation, criminal appeal, speed 114 WPM, recorded by Rizwan Ansari. Ready, start. As discussed earlier, the complainant was at the mercy of the accused as according to his version he, along with the two deceased, was encircled and was under direct and immediate threat of death, but he was still able to give photographic narration of the occurrence by attributing individual role to each of the several accused, inflicting injuries with hatchets and firearms on specific parts of the bodies of the two deceased. Stop. This fact, by itself is sufficient, to disbelieve his presence at the crime spot at the fateful time. As we have already declared that investigation conducted in this case, was neither fair nor honest, therefore, the recovery of the so-called crime weapons has also lost its legal worth, which otherwise, is not implicating the appellants except Sajad. It is also pertinent to mention here that, that the attesting witness to all these recoveries of incriminating articles is M. Sharif, PW9, whose testimony we have already disbelieved as a whole. Stop. It is fundamental principle of justice that corroboratory evidence, must come from independent source providing strength and endorsement to the account of the eyewitnesses, therefore, eyewitnesses, in the absence of the extraordinary and very exceptional and rare circumstances, cannot corroborate themselves by becoming attesting witness to the recovery of crime articles. Stop. In other words, eyewitnesses cannot corroborate themselves, but corroboratory evidence must come from independent source and shall be supported by independent witnesses other than eyewitnesses, thus, these recoveries are equally of no judicial efficacy. In this case, some of the accused have been killed allegedly by the complainant party and some died during imprisonment. Thus, the private execution to death of some of the accused, by the complainant party, would suggest that they themselves took the revenge from those, who were involved in the crime, albeit, the learned counsel for the complainant strongly opposed this view, but he was unable to controvert that some of the accused have been killed. In view of the analysis and combined study of the entire evidence by way of reappraisal, with such care and caution, we are of the considered view, that the prosecution has failed to prove its case against the appellants beyond any reasonable doubt, therefore, this appeal is allowed, and while extending benefit of doubt to the appellants, they are acquitted of all the charges levelled against them. Stop. For the serious reasons given above, criminal appeal filed by MST Rukhsana Begum is dismissed.